All right. Good morning, San Francisco, California. My name is Feras Mousilli. I am a lawyer here in the Bay Area and a good friend of Christina's when she was out here in San Francisco working with various startups and groups here. So I'm going to give you a quick introduction to myself. I am the managing partner for Mousilli LLC. I was previously senior counsel at Apple, and before that, I was senior counsel at Dell. I was in patent litigation and the intellectual property sections of DLA Piper, a big law firm that's fairly global. My educational background, I've got a doctorate in law from UT Law in Austin, Texas. Before deciding to go to law school, I had thought that I wanted to be a physician, follow kind of in our traditional Middle Eastern, Syrian, Lebanese roots of always going on to medical school. Big disappointment to my parents not pursuing medicine and instead opting for law. But I had actually done computer science and biomedical engineering at Johns Hopkins. So I've got a bit of a technical background in both, sciences and engineering. So it's made me fairly uniquely qualified to be able to advise technology companies in various areas and focus on intellectual property. So wanted to give you a quick overview of our presentation today. We've tailored this to the WeWork Labs initiative that Christina is managing here. We wanted to focus on three main areas based on the feedback on your pilots. So we'll talk about confidentiality initially in NDAs and confidentiality clauses. We'll then turn to IP and technology generally, delving into the types, various costs, and finally we'll talk about pilot contracts and some of the typical clauses that you see and some of the concerns that may arise from those clauses in the agreements that you'll be seeing. So with that, we can end up opening it to questions at the end if any of you have anything that you'd like to discuss in particular. So with that, we'll go ahead and dive into confidentiality. I see, do we have a question that was coming over? I'm not sure if we want to have this as kind of an interactive session, Christina, or if you prefer to simply maintain the questions till the end of the presentation.
Yeah, if you're okay with interactive, if anybody has a question, either feel free to type it in the box or politely interject.
Perfect. All right. So confidentiality agreements. You've seen these inevitably whenever you're doing any type of pilot or early conversations with companies. And what's really important to note is that these NDAs, or non-disclosure agreements, as they are commonly referred to, may very well seem innocuous, but oftentimes they'll have a few gotchas that are included. So it's really, really critical that you always read the entirety of the NDA. They may seem like form agreements, or you're told that these are standard templates, etc. There really isn't a standard template for confidentiality. And really, it all depends on the individual circumstances of the relationship, the parties, etc. So again, it's critical to read the entirety of the agreement. And we'll talk about some of the clauses that'll come up that you may be concerned with. We'll also end up discussing common responses, etc. Now, you really need to be thinking holistically about the relationship when you're entering into any kind of confidentiality agreement, just because of the various restrictions and impositions that it'll have on the data that's being shared. So with that, it's also critical to think about what happens next, right? Oftentimes, people think of an NDA as simply a document that ends up getting filed away in a cabinet somewhere and never looked at again, without thinking about the eventual termination of that relationship, or what's likely to happen in the next stages of the way that that relationship ends up developing. So with that, it's important to recognize that NDAs and confidentiality agreements are not one size fits all. These are really agreements that should be tailored or customized to the particular circumstances of the relationship. You always have to think about who are the parties that are involved, right? What's the purpose that you're engaging in this conversation or relationship in the first place? Is this something that you're looking to simply explore a potential relationship early on? Is this something that you're doing as a precursor to a bigger negotiation? In that sense, you have to also think about the type of agreement that comes into place. So these NDAs are various flavors as well. Sometimes you have what they call mutual NDAs, where it's a two-way obligation, right? It's a bilateral contract where you're exchanging information on both ends, where both parties are disclosing something that they believe to be either proprietary or confidential to their organization. And that's really critical to understand, because it ends up imposing obligations on both parties, as opposed to when you might be entering into an agreement with a independent contractor, where it should be simply one way, right? Where you, as the organization that's hiring the independent contractor, are providing confidential information to them, not expecting them to provide confidential information in exchange. So that's one of those, critical turns that you should be able to accommodate and understand whenever you're working through an NDA. I'm also gonna talk about the period of the agreement, right? A lot of times, folks realize that there's a standard contract that comes across that has a 2-year, 5-year, whatever confidentiality period. And that's really open for negotiations. And it's really important, and we'll talk about that in these following slides, about how that period can end up being negotiated and how it should be customized. And finally, you need to really think about how the data is exchanged between the parties. So if you're having a joint development where you have individuals or employees from one party on premise, right, and they're actually able to interact with the team, it's a lot looser than a virtual relationship where information is only being exchanged through data rooms or other formal exchanges. So we'll talk about that here in shortly. Some of the clauses that should always be in your NDAs. The first one should be an explicit limitation on the right to use that information that's being disclosed. So depending on the type of relationship, depending on the information that's being exchanged, you want to make sure that you have a very clear limitation on the other party's ability to use that information. Meaning, if you're providing sensitive information related to your product roadmap, it's not something that you would ever expect them to use outside of the individual group that is making the evaluation on the joint development, for example. So it's important to make sure that the purpose of the agreement is fairly spelled out early on within that NDA. Something else that's also really critical to include within that NDA is a clause for injunctive relief. So a lot of times you're providing, the secret sauce to the companies, things that are actually mission critical to your company's development. And for another party to be able to disclose that or use it in some inappropriate way, it's critical to have a clause that allows you to go to a court and demand what they call injunctive relief, a relief from the court to prevent the other party from continuing to use or disclose your data or your intellectual property in a way that is harmful to your organization. The other clauses that we'll end up talking about too is archive data. What ends up happening inevitably when you've got systems that are making backups and other kind of archival copies of the information that's being exchanged. A lot of times, it's not just what's on your hard drive, right, or on your personal system that you're concerned with, but people's ability to later on be able to mine that. And we'll talk about that clause here shortly. The definition for the period of confidentiality is also something that oftentimes is just seen as mechanical, right? Some term that may not actually reflect the information that's being exchanged. And we'll talk about form, venue, and some of the markings, but a lot of times within these NDAs, they'll end up calling out the only information that's actually that's confidential is information that has been marked as top secret, confidential, internal use only, etc. So you want to make sure that the actual language of that NDA is broader than that. It's not limited to only information that may inadvertently be exchanged and hasn't been marked properly. So the biggest concern is usually that period of confidentiality, the information that's being exchanged. How long does it actually need to be maintained as confidential? And you'll see, like the graphic that we've got to the right, there isn't any kind of complex formula that exists to end up determining what that actual period of confidentiality should be. You should really be thinking about the type of technology that's being used, right? So obviously, if we're talking about software, the developments that are happening are rapid and quick paced. So some software innovation that may be very, very relevant or a product roadmap may be confidential for a quarter or two, but it's not really something that you would expect to be able to protect for 2 years, for example. Obviously, once a product announcement has been made, the cat's out of the bag. There's no real confidentiality that should be included there. You also want to be thinking about whether you're actually planning on filing for patent protection related to the information that you're exchanging. So the US Patent and Trademark Office and global trademark and, or rather patent offices have prohibitions against public disclosure. So if you've disclosed the subject matter of your patentable matter a year before that application takes place, you can end up being barred from your ability to actually patent that invention. So that's a consideration within that period of confidentiality, right? You want to make sure that, hey, if you're making an exchange, it's at least for that year if you're actually planning on filing a patent and having done so beforehand. Something else to think about is the type of information that's being exchanged. So obviously, if you're talking about competitive data or something that's very, very sensitive to your organization, you may have different periods of confidentiality tied to those different types of exchanges. again, with a product roadmap example, that might be something that you only tie, for 6 months, 9 months, whatever that period might be, versus information related to your actual trade secreted processes, methods that you may not have other types of intellectual property protection for. And we'll talk about that later. I wanted to provide some actual practical advice related to some of these contracts as well. And, if this gets, too in the weeds, we can pull back out. But it's important, even as business folks, to understand some of these basic clauses that are included within the contract. So you'll see, we discussed earlier this idea about archived data, right? The backup systems that exist. And it's important to end up including a clause because typically at the end of a confidentiality agreement or other kind of NDA, you'll end up seeing that there's a requirement to destroy all copies in the possession of the other party, etc. Sometimes you actually have a certification that you have in fact deleted, destroyed all copies. The exception to that is often just related to archival copies, that, hey, we can't really control this. This is part of our standard process to be able to back up and store information. The response to that should always be, that's well and good, but we have to make sure that we have a clause related to the accessibility of that information. And you'll end up seeing that this clause in particular allows for those archival copies, but it ends up ensuring that, hey, they're not readily accessible and are not allowed to be used for any other purpose beyond the agreement. So that's a typical clause for archival information. Now, something that will often come up is whether you should end up including a choice of law and venue clause within your non-disclosure agreements or any contracts for that matter. And as a startup, as an early stage venture, money is very tight, your budget concerns are looming large. No one likes to think about the prospect of actually having to litigate or to go enforce their rights through injunctive relief, etc. But the ability to do so and to think about that is one of the things that's critical for ensuring that you can actually exercise your rights in a cost-efficient manner. So it's always recommended to include a clause related to the choice of law and then the actual venue. So the choice of law will obviously vary depending on your state, right? And where your startup or your headquarters are and where your founders and other team members are. And it's a lot less costly to be able to litigate in your own backyard. So again, it's something that's often more important to the smaller party within a contract negotiation. Now, obviously, if you're located in a state like Louisiana or New Orleans, that may have very different bodies of law than what folks may be accustomed to in New York or California or Texas. You may have difficulty negotiating a venue or choice of law other than those big states. But again, as a smaller entity, it's usually worth your while to make the request on these contract negotiations related to choosing a particular law to be applicable and a venue. Let's talk about residuals. This is also a clause that's often included within confidentiality agreements that you should also end up looking into more closely when you're doing these confidentiality agreement negotiations. So the idea of residuals is this idea that, hey, even if, you know, I have the best of intentions and want to abide by a confidentiality agreement, I have elements of this confidential information that's beyond the actual documents and files that have been provided, that there is something residual within your own unaided memory that the other party may want to control the disclosure of. So typically you'll end up seeing a clause that just says, hey, you know, confidential information doesn't include this information that's residual or resides in the unaided memory, right, of an employee or contractor. You should consider a narrower clause because that in and of itself isn't enough protection related to potentially your trade secrets and the way that you're operating. So the more narrow clause that's provided on the right can be very, very helpful in kind of limiting the ability for the other party to be able to utilize you know, your trade secrets or other information that lives beyond the actual files exchanged. This is the final slide within this confidentiality conversation, but it's really important to designate a single point of contact on your team for any type of data exchange. So if you're actually providing a data set, right, to the other party that you may be contracting or piloting with, having one person serve as that point of contact will ensure a holistic view of what information has been exchanged. That ensures that, hey, we don't have people inadvertently providing source code or other very sensitive information to the other party in a fashion that you know, is ultimately hurtful. The other thing that you need to be aware of is that in this kind of limited engagement, especially within a pilot, be mindful of what information that you're actually exchanging. Right? It's a limited engagement for a reason. Both sides are still evaluating whether this is an opportunity that makes sense for them or not. So it's important not to give away the crown jewels of the company. So the other thing that you should be aware of, make sure that any files that are being exchanged, any data, whether in the email itself or the documents itself, that you have a confidentiality marking in there, designating the name of your company and that it's confidential, proprietary, secret, whatever phrasing that you want to use. There's a bunch that are available. I've provided an example line, right? ABC Corp confidential information. That's enough to at least put the recipient on notice that the information that you're providing is in fact confidential. Now, obviously, don't veer to the opposite extreme where every single email and item that you're providing you've marked as confidential, because obviously that's going to end up lessening the impact of seeing those words. So try to maintain a grasp on the information that's being exchanged and to mark it appropriately. So I'm going to pause there for a second before we turn to intellectual property. Do we have any burning questions about confidentiality before we dive into intellectual property? Excellent.
This is Jeff Bourne. Just one quick question. Of course, have an attorney looking over writing a premium is the ideal state. Is there, though, any template you'd recommend to go to? I've seen a bunch, but they seem to vary from what you're saying, that you'd recommend to just start off with. And then, of course, have your attorney review for any special agreement that you have with the other party.
Yeah, absolutely. I'd be happy to provide our firm's base template for some of these confidentiality agreements, but again, it just depends on the situation, right? You can have a lot of forms that are out there, but if you haven't actually customized them to your particular needs, you know, it's the same thing as having, you know, a suit that was made for someone else that you're wearing. It may accomplish, you know, your you know, some of your objectives, but a lot of you may very well still be exposed.
Great, thank you.
My pleasure. So, intellectual property. I'm going to turn to an overview of just the different types of intellectual property. You guys are fairly sophisticated. I'm not going to bore you with the, you know, extreme basics, but it's important to differentiate between the various types of intellectual property. Patents are related to inventions, methods, processes, technologies, chemical compositions. There's a range of items that may be patentable beyond what you would typically think of. People often don't recognize the threshold necessary for an invention to actually be patentable by the US Patent and Trademark Office. And there's essentially three elements that they have to end up looking at. It has to be new or novel, useful, and non-obvious. So this non-obviousness piece is often what people get tripped up by. Non-obviousness is actually a legal standard under an acronym called FOSITA. It's person having ordinary skill in the art. So it's not what's non-obvious to a layman or someone on the street, but what's non-obvious to someone who, again, is a professional who's working within the particular sphere. So that's the first type of intellectual property, patents. Trademarks, you'll end up seeing will protect businesses, services, products, and slogans, right? It's something that's critical, especially as an early stage startup, to make sure that you've provided a clearance search for your ability to use the name for your company and your products, services, etc. The last thing that you want is 9 months into your venture to receive a cease and desist letter from some other company saying that you're infringing on their trademark, and you have to go through the hassle of rebranding, taking down marketing, etc. So it's something that we highly recommend that you take care of very early on. Copyrights. So people typically think of copyrights as only being within the realm of movies and songs and other kinds of works of art, but that's not the case. There's a huge range of items that can be copyrighted within the business realm. So think about some of your manuals, your brochures, your marketing materials. And you'll ask yourself, hey, is this actually worth registering a copyright on? And the answer that I typically give our clients is, if this is something that you're concerned with a competitor copying, using outright, you should go ahead and register a copyright on it. The reason why, it's often a lot easier to enforce a takedown. So for example, if a competitor or some reseller, some other third party is reusing some of your images, right, for even your products, right, or some of your brochures or some of your product descriptions, etc., that your marketing team has put together, it's a lot easier to send a cease and desist or a takedown notice to, an Amazon or an eBay that will comply with a registered copyright. I'm gonna just glance over this because I think this is really useful information for startups that obviously maybe a little more difficult to come by. But just to give you a little bit of a sense of what the costs typically are associated with the various types of intellectual property. Patents come in, two basic flavors, right? You have a utility patent that ends up covering the function of an invention, and then you have a design patent that only covers the non-functional elements of a design or product, etc. Utility patents fall into two basic categories. You have a provisional patent, which, as the name implies, is something that you apply for initially, and it provides a limited protection of a year from the date of your filing, at which point you have to either convert to a non-provisional or abandon your application. The cost of a provisional is much less than the cost of a full utility patent, just because there's a lot less formality involved in the claims and in the forms that are required to be filed by the U.S. Patent and Trademark Office. Trademarks, the typical cost to end up preparing a trademark application is about $1,000, and you'll have various classes. You have to apply within a particular class to end up getting a trademark protection. And this is the reason why we can have Pioneer as a trademark for electronics, and we can also have Pioneer as a trademark for building materials and other elements. You have two completely unrelated classes of goods and services, so there's not this risk of consumer confusion. Something else that we end up advising a lot of our clients to do, especially if they're operating within particular states or geographies, is to file for a state trademark, just because with a federal trademark, it takes at least 3 months before the U.S. Patent and Trademark Office will even look at your application. So it's often a good idea to just get a state registration to be able to point to as well, in case you have these other kind of trademark infringement allegations that you want to make, or to be able to defend against. Finally, copyrights. It's a little more straightforward, right? It's a lower filing fee. Technically, you don't even need to register a copyright with the Copyright Office, but there's a host of benefits to having it registered, including the ability to collect treble damages, triple damages, and attorney's fees from infringers. So I'm gonna close on the cost of copyrights and intellectual property here, and turn to an important distinction that is going to be critical in our next topic of conversation. So people often talk about intellectual property as this very vague notion of protections and items that end up getting being the subject of the contracts and agreements. As we've seen, we've talked about the three registered types of intellectual property: patents, copyrights, and trademarks. The fourth and very important type of intellectual property that we didn't discuss is trade secrets. Trade secrets are elements of information that have commercial value by being maintained as confidential. The most classic example of a trade secret that's often cited is the formula for Coca-Cola. That actual, chemical compound and the process by which Coca-Cola is manufactured has been maintained as a very closely guarded trade secret within the Coca-Cola company. You and almost every other company will have trade secrets related to not just things that may be patentable or copyrightable or even trademark. You'll have information related to your customer list, right? The folks that you've actually contracted with that may not be public, that you would not want a competitor to have access to. So it's important to think about this fourth class of intellectual property as something else that may or may not be the subject of some of these agreements. Now, I want to draw the distinction between intellectual property and technology, because a lot of times within these agreements, you'll end up seeing licenses to the technology. And the technology is broader than individual intellectual property. So you may be licensing some of the software that may not have the traditional intellectual property protections. You may be licensing your platform or other know-how. So it's important when you're reading these contracts and agreements that you know that there is a distinction, right? And oftentimes within the definition of the agreement, you'll see a distinction between technology and intellectual property. I'm going to pause there. Do we have any questions about intellectual property before we dive into some of these pilot agreements and the concerns there? All right, moving right along. This is a cartoon, by the way, that I love, and I do have a license to the use of this cartoon. It's really important, even when you're using presentations or putting together marketing material. Just because you find it on the internet doesn't mean that you can end up using it. So I actually have a license from the artist, Alex, who's granted us permission to be able to use this comic, which I just find so hilarious to be able to see a unicorn being handed a copyright infringement notice by a narwhal, right? And no longer being able to sport the horn. With that, I wanted to talk about the various types of agreements that you'll end up seeing as an early stage startup, and especially around pilots. So typically you'll end up seeing a license to your proprietary materials, right? That the recipient or licensee has a right to use, and you'll end up defining the various terms related to how they can end up using it. What we've typically used for our clients are evaluation agreements or beta agreements, depending on the stage of development of the technology that's being licensed out. The evaluation agreement typically allows a customer or potential client to end up having a free use of your platform or technology, or a not free use. It doesn't necessarily need to be free, to be able to evaluate your technology and provide real feedback, see if they can integrate it into their systems well enough without any further concerns. Technology service agreements are in all types of other flavors as well. So you may very well be doing a software development agreement as part of your pilot, depending on the type of engagement and what you're really trying to accomplish there. You have software as a service that's become very, very popular. Instead of actually being able to, provide copies or some other, downloadable functionality of software. Instead, you're providing it on some kind of cloud platform. I want to turn to some of the clauses that you'll end up seeing within these agreements, and specifically focus on intellectual property. So to start off with, I've got this kind of anecdote about Volkswagen and Rolls-Royce. and this wasn't a pilot, this was an asset purchase agreement. But it's important to just illustrate the scope of an agreement and making sure that all of the intellectual property or all of the things that you're trying to capture are in fact captured. In this 1998 example, Volkswagen had acquired the plants, the employees, the designs, the equipment, almost everything from Rolls-Royce except the trademark. So even though they had all of this ability to manufacture engines and other components based on the intellectual property of Rolls-Royce, they couldn't end up marketing under that trademark because they hadn't acquired the rights to that trademark. And that's really important to ensure that whenever you're looking at the work product that you're contracting around, to make sure that you're capturing everything that you're intending to be able to commercialize. So you'll see two various flavors of work product that are included within, service agreements specifically. So a lot of times, the company receiving the services want something to be very encompassing. Hey, that we own everything related to the performance of the services that you're providing. So that is oftentimes dangerous for the service provider, because if you've actually developed something completely new, something beyond the typical services that you provide, that work product could very well encompass these inventions or methods or processes or code that you've developed, right, as part of this service delivery. And that's why oftentimes limiting the deliverables to what's specifically identified within the work order is preferable in some circumstances. Now, the other thing that you want to think about is, are these services or deliverables that you're providing, are they dependent on other software that you've got? So is the fact that you're building some kind of bridge code for implementation within an API, that's clearly work product of the recipient. But what about the background software that's being used? Do you have to maintain a continuous license? So it's really important to make sure that that's captured as well. We have clients within the self-driving car space that are developing machine learning tools for being able to identify visuals, and the amount of data that's provided by these car manufacturers through their LiDAR systems is massive, and it's also considered proprietary. But the ability of our client to be able to process this information and train their machine learning algorithms is also critical. So you have to make sure that it's clear that you have a right to use that data set for certain purposes. So within these definitions for intellectual property and intellectual property assignment, you have to be clear about who owns what, right? And if you end up having a license to that background technology. So one of those other considerations within a pilot or an evaluation agreement relates specifically to a term called feedback, right? And feedback, just as the name implies, is, when you're doing an evaluation, the evaluee is providing all types of information related to your product or service. And that information or feedback may have very valuable information, potentially even patentable subject matter, right? If they're telling you, hey, this needs to be adjusted, or it would be better if you could do it this way, that feedback that's being provided under normal circumstances, if you don't have a feedback clause, would be owned by the person that makes that invention or makes that suggestion. And that is a unfortunate position to be in if you've developed all of the initial technology and are seeking that kind of information to improve your own product. So having a feedback clause is often very critical to your ability to commercialize based on that feedback. A lot of times it doesn't necessarily need to be something patentable, but even the idea of results, right? Performance results that may come out of, you know, a platform that they're testing for you. Those results and the data related to those results is something that you want to make sure that you have a right to use and be able to commercialize. So we are just about at our time. So I wanted to save a few minutes for questions from the audience, just because I know we've been very fast and furious in this presentation, and we've covered a lot of ground.
Hi there. I have a quick question for you. Sorry, I got two screens going, so I'm looking up and talking down. So a question that I have for you is maybe a little bit of an atypical one, but a lot of us, I would assume majority of us, are working with legal advisors. And some of the challenges that we run into is purely from a cost standpoint that, you know, we've got one small revision and next thing you know, we've got a $500 or $1,000 bill for just the labor that typically comes from your side. Not specifically you, obviously, but your side of the house. Do you have any advice for startups, like getting outside of the legal aspect of it, but like how to better work with you, or advice that you have for someone like us where financially we're trying to be extremely intentional about where we put our chips, like how to use them in a better way with people like yourself?
Amazing question. And it's at the top of everyone's mind. Obviously, the costs of legal services are often what's prohibitive, you know, and, you know, a barrier to folks seeking out advice when they really should be. I think, number one, you have to educate yourself, right? That investment in understanding an agreement, not just pushing things off. This is legal, this is legalese. Let's just, you know, push it out to the lawyers. And I can tell you this because I've served both as outside counsel and in-house at various corporations, right? So the best client is an educated client. So that's something that we always strive to do, is make sure that we explain what these various clauses mean. And where it's really critical to end up seeking out that advice. So part of the challenge here is that even with something like a work order or service order, a lot of times the business people haven't developed out a real clarity related to what those deliverables look like, what the various responsibilities are. You can save yourself a lot of time and headache and cost by thinking through that before you just hand it off to a lawyer to develop out. The other thing that I can end up telling you is focusing on, you know, a couple of key clauses. You know, intellectual property, obviously critical. Indemnification, right? What you're responsible for should, you know, this thing, you know, figuratively or literally blow up. Your limitation of liability, the actual, you know, cost out of pocket. These are the type of clauses that every business person should become very, very familiar with, so that they can at least understand the initial concerns and then be able to target specific issues to bring up with their lawyer. A lot of times, if you've already worked through an agreement and you've had your lawyer draft a master service agreement or whatever type of agreement, you can end up limiting the review to the particular clauses that you know, the clients or the customers may have issue with. And I think that's really critical in trying to limit the focus of any kind of conversations. Because to be quite honest with you, the majority of these questions are ultimately business decisions, right? there's a cost involved with each of these concerns about, venue, for example, where you end up litigating, or what the financial responsibilities are of each party. So those are a couple of the suggestions that I have to try to limit your costs and limit the review, especially if you're cost sensitive.
Thank you.
My pleasure. Any other questions?
Hi, Feras. I have a quick question. And I think it's more of like a situational question, but oftentimes startups, when these agreements come into place, you're more or less fed something from a larger corporate that's got a pretty robust, massive legal team. Like, just kind of situational wise, like when a startup encounters something that is essentially a violation of maybe some of their IP and NDA, like what have you seen as like the best way to go about that? As Brad mentioned too, when you don't actually have like full-time legal support in that sort of arbitration phase.
Absolutely. That's a tough situation for any startup to be in, especially if there's this, suspicion that part of your intellectual property is being misappropriated. I think what's really critical to do is to maintain relationships. And I think if you've talked to whoever the executive is that was responsible for the project, that would be the first course of action. To at least, put them on notice and tell them, listen, these are our concerns. This is the basis for our belief that this information is being misused or otherwise misappropriated. I think it's, one, you have to end up establishing a clear paper trail. So you don't want to be overly aggressive in those initial communications, but I would send an email that said, hi, Brad, we're really concerned with this, and this is the reason why. We'd love to have a conversation about this. But I would make sure that you document this consideration. Now, most legal departments, especially once you end up receiving a letter like that, they're going to take it very seriously. It triggers all kinds of responsibilities on their part in terms of holding data or records as part of potential litigation. They've got disclosure requirements. But it's important to just have these conversations. And if you feel like your IP is being used inappropriately, that's absolutely the time that you should go and consult an attorney and get a professional opinion on something like that. Have I completely addressed your question, Christina?
Yeah, no, that was very helpful. Thank you.
My pleasure. Any other questions before we hand it over?
All right, wonderful. Well, thank you again for us. I think that was very helpful to kind of get the broader landscape. And then I think you mentioned you have a template potentially that you can share. I will get that and pass that around. And again, thank you so much for your time today. And thanks, everyone. I hope you enjoyed the session.
Yeah, thank you very much. That was really great.
My pleasure. And if any of you have any questions, feel free to reach out to us. Our firm information is up on the slide. Christina has it. I'm happy to share these slides as well, Christina, if that's helpful for the folks that weren't able to attend today.
Definitely. I will get those from you as well for us. Thank you.
Thank you. Have a nice weekend.
My pleasure.
Thanks, everybody.